Okay, good afternoon, good morning, happy Friday. Um, Thank you for joining us for our panel, Improving Access to Justice, Technological Innovations in Legal Design, the first in a little 3-webinar series on access to justice put on by the ABA Young Lawyers Division. My name is Tyler Holmes, and I'm the YLD Director for Legal Innovation for the current bar year. And I'm also a Senior Program Officer in the American Bar Association Rule of Law Initiatives Africa Division. Our panelists are Ellen Rosen, who's the Regulation and Global Initiatives Counsel of the ABA Center for Professional Responsibility. Ellen advises the ABA Standing Committee on Professional Regulation. The committee's mission is to assist the judiciary and the bar in the development, coordination, and strengthening of professional regulation throughout the United States, including the assessment of the ramifications of global legal regulatory and practice developments. Ms. Rosen was counsel to the ABA Commission on Ethics 2020, which reviewed and recommended changes to the ABA Model Rules of Professional Conduct and the U.S. system of lawyer regulation in response to the challenges that globalization and advances in technology present to clients, lawyers, law firms, and the public. She frequently speaks and advises various bar entities, including the International Bar Association, as chair of its Bar Issues Commission Regulation Committee on Ethics, the Regulation of the Legal Profession, and Professionalism. Prior to joining the Center for Professional Responsibility in 1996, Ms. Rosen was a senior litigation counsel with the Attorney Registration and Disciplinary Commission of the Supreme Court of Illinois. She is president of the Board of Governors of the Chicago Council of Lawyers, Chicago's Public Interest Bar Association, and has served on the council's executive committee and board of governors for a number of years. Ellen received her JD with honors from the Indiana University School of Law. Alexander Rabinal is a research fellow and associate director of the Law Lab at Chicago-Kent College of Law. Alexander helps lead the law school's legal innovation and technology program and teaches classes in technology-assisted access to justice, ethics and professionalism, and technology and innovation across legal markets. Alex received his BA from the University of Illinois and JD from Chicago-Kent. And finally, last but not least, Hallie J. Pope is a visiting associate professor at the University of Utah S.J. Quinney College of Law. She's a legal information designer and cartoonist. Hallie founded and leads as president the Graphic Advocacy Project, a nonprofit that uses visual communication tools to explain legal concepts. After graduating from Harvard Law School in 2014, Hallie clerked for the Honorable Roger L. Gregory on the U.S. Court of Appeals for the Fourth Circuit, and then served as a litigation fellow and legal cartoonist at the American Civil Liberties Union of Massachusetts. Thanks all for joining me. We are going to start with a bit of a presentation and then open up into Q&A after that. So I will turn it over to Ellen to get us started talking about access to justice in general and various approaches to narrowing the access to justice gap.
Great. Thank you, Tyler, and welcome everybody. Before I start, I need to get a little disclaimer in that my views or positions are my own and not those of the American Bar Association, other than when I refer specifically to its policies. So, setting the table. So I think what we're really talking about today is designing today the legal profession of the future. And for my part, that's going to be through a regulatory lens, because we need to not only better address the access to justice crisis, but the access to legal services crisis. And they're really, I think, two distinct things. And regulatory innovation can also help ensure sustainable practices for lawyers as well. So increasing access and helping lawyers have more sustainable practices. Next slide, please. So some of you may have seen this iceberg before in presentations about access to justice. The 2022 Legal Services Corporation Justice Gap, as well as other reports, have made pretty clear that despite best efforts by the profession and by allied professionals involved in our legal services ecosystem, the access gap remains largely unmoved and is growing. We've tried volunteering it away. We've tried donating our way out of this. And frankly, we can't. It's just not possible. And so when you look at that and also look at that in context with the fact that the US as of the 2021 Justice Report, ranks 109th out of 128 countries in access to justice. We've got to do something differently. So generally speaking, and the reason I use this iceberg is because 85% of our population is really either unserved or underserved by the profession. And so that is the underwater piece of the iceberg. And we often think of that 85% as being made up of those who are at or below the poverty line, but that's really far from the case. Next slide. So this kind of breaks down the iceberg. You see at the top, that's the market lawyers are now serving. And then you see kind of in the middle there, who are people in need of legal solutions or who don't know that they need legal solutions. And you've got a variety of service providers. You've got lawyers who are offering limited scope services, allied legal professionals, and on the technology front, you've got some lawyer-assisted tools and user-centered tools, as well as community-based assistance. And then at the very, very bottom there, you've got those people in need of financial assistance and legal aid. Next slide, please. So what we've found is when you look at the studies, is this runs right up the income level ladder. So I've got some data here for you. Everybody likes data. But what I think was particularly telling to me was that California Justice Gap Survey, where you have 85% of Californians getting no or inadequate help for their civil legal aid problems. And a giant chunk of those are in middle income. So it's not just those at or below the poverty line. And you can see again from the Legal Services Corporation Justice Gap Report from this year, 92% of problems by low-income Americans are still not getting any or enough legal help. Next slide. So I mentioned earlier, we can't volunteer or donate this away, and I think this kind of helps, have you envision that. It would basically take 180 pro bono hours for every single lawyer every year to try and make a dent in this problem, which is pretty amazing. And then I think the other thing that really kind of made this hit home is when you look at this quote from Jim Sandman, who's the president emeritus of the Legal Services Corporation, which is basically funding for that entity is less than what Americans spend every year on Halloween costumes for their pets. Next slide, please. But it's not just people who need legal services who are struggling. Lawyers are struggling too, and that's something that I think often gets overlooked in our conversations about access to justice. And when we talk about regulatory innovation, we get very focused on that access piece. But lawyers are having a hard time too. And most lawyers in the United States are solo and small firm practitioners. They're not lawyers who are operating in larger firms. And so it's no less important, I think in my view, that we focus our regulatory innovations towards helping lawyers have sustainable practices. And I think that's also going to be helping the access piece. And that was, for example, the focus of a report submitted to the Illinois Supreme Court by the Chicago Bar Foundation and the Chicago Bar Association. So the other thing that stood out to me really is the CLIO data. When you look at the fact that in 2020, the average lawyer, solo, small firm practitioner, medium firm practitioner, billed just 2.5 hours a day in an 8-hour day. So there's got to be a way to help lawyers increase their billable hours, and not necessarily increase their work. And I think Alexander and Hallie are going to be able to talk a little bit about some of that as well as consumer-facing technologies. So there's a lot more happening. Next slide, please. So how do we create solutions? Because I think what we're dealing with is a current system that wasn't designed for today's reality. Everything evolves. Things keep evolving. Technology continues to evolve. I think it's pretty fair to say, and I am hoping my colleagues agree, that it's always going to outpace us. The justice gap, as I mentioned, continues to grow. And so I think we need to be, more agile and adaptable in how we approach this problem and working to solve the access gap. And I think, interestingly, we see a lot of tension sometimes in conversations within the profession that people somehow think that solving the access gap through regulatory innovation and enhancing lawyers' sustainable practices are concepts that are antithetical to each other. I don't think they are. And I think it's clear that maintaining the status quo isn't an option, although change is a scary thing, especially for lawyers. Next slide, please. So I think the important piece is that people understand that in looking at how to address the access gap and at the same time help lawyers develop sustainable practices, there is no one size fits all solution. And I think you'll see some of that when I talk further today about what's happening in jurisdictions. And I think it's important also to know that in developing these kind of jurisdictionally appropriate or tailored solutions, that there's a lot of collaboration happening. It's being led by state Supreme Courts, it's being led by the organized bar, but they're bringing in other stakeholders with broad expertise in technology, legal design, and the public as well, because really what we're looking at is we have to understand what the consumer of legal services needs and what they want from us. Next slide, please. So the regulatory lens I'm going to focus most of the rest of my remarks on are about authorizing and regulating paraprofessionals or allied professionals, as the National Center for State Courts calls them, to provide directly to consumers, either with or without lawyer supervision, limited scope legal services. Arizona and Utah have more recently implemented programs. You see the Arizona legal paraprofessionals, as well as the Utah licensed paralegal practitioners. And what the courts did, and these were the state Supreme Courts that adopted these changes, was they looked at the areas where you had the most pro se representation, typically family law, landlord-tenant, debt collection cases, and they developed their programs around those areas. And so you can see here a little bit about what these paraprofessionals can do. They are able to operate without lawyer supervision, but there are entry requirements and there is regulation and discipline. So you have different paths to entry for these allied professionals. It's either educational or experiential. They are subject to rules of professional conduct, just like lawyers. In fact, in Arizona, they incorporated these individuals into the rules of professional conduct for lawyers, and they are subject to regulation and discipline. But I think the other thing is, because there's been a lot of pushback in certain areas of the profession against this. I think it's important to note that conceptually, this isn't even close to being new. It's been going on for decades at the state and federal level. You've had bankruptcy petition preparers in federal courts, authorized representatives who are not lawyers that are able to represent claimants before the U.S. Patent and Trademark Office, tax court in immigration matters before the EEOC. Arizona has had certified legal document preparers, I think, since 2003. Washington State, limited practice officers for real estate documents. That's different than their triple LTs, limited licensed legal technicians. Legal document assistants in California since 2000, and Nevada has licensed document preparers. So not a new concept, just a different way of approaching it. Next slide, please. And so Utah and Arizona are not alone. There are a number of other states who are acting, smaller states and larger states. They're each taking different approaches. The Minnesota Supreme Court launched a paralegal pilot project in March of 2021. It is currently set to last for 2 years, but they're looking to extend it as well as expand the scope of services that these individuals can provide. And when the court looked at setting this up, they stated their goal in doing so was to increase access to civil legal representation. They held public hearings, they got public comment, and they created an implementation committee that spent a year before launch assessing the needs of the courts, assessing the needs of consumers, and various other options before recommending not just how to implement the program, but how to evaluate its success. So they established new case management codes in their system to track these individuals' representations. They trained court staff, they trained judges, and they developed a complaint process for the pilot so that if a consumer had a complaint, that could be handled, and they worked with the Minnesota Lawyer Discipline Agency to do that. Unlike Arizona and Utah, these paraprofessionals have to be supervised by lawyers, and they provide similarly services in family law and landlord-tenant matters. the supervising lawyer has to have malpractice insurance and assume professional responsibility. Just a couple of months ago, the Oregon Supreme Court has followed suit and approved a licensed paralegal program. They're in the process of developing the rules and regulations for the entry requirements, as well as for licensing and regulation and discipline. And they've been considering this for some time, and they've had very broad support from judges and the public. And the initial kind of loud opposition from the profession seems to have faded over time. These individuals, once licensed, will be associate members of the Oregon State Bar. No lawyer supervision will be required, and similar to Arizona, Utah, in terms of multiple paths to licensure. They also must have malpractice insurance, pay into the client security fund. And kind of as a little preview for our discussion about alternative business structures, they are able to share fees with other licensed paralegals and lawyers, and they are able to own firms with lawyers and other licensed paralegals, just not others who are not lawyers. And that's similar to Arizona and the Utah sandbox. As in Minnesota and in Utah and elsewhere, they're going to ensure that data is collected so they can actually evaluate the program and its progress. And just last week, the Connecticut State Bar Association, its legal profession task force, issued its report recommending that its court create a committee to work on developing a program to license what they're calling non-lawyer limited legal advocates. So we'll have a new acronym, LLAs. And so that is on the horizon, as well as Colorado. The Supreme Court is looking to adopt a licensed legal paraprofessional program. Similarly, theirs would be limited to, I think, domestic relations cases initially. So a lot is going on. Some of you may be thinking, well, that's great, but what does that have to do with practice sustainability? Well, interestingly, what they have found initially in Minnesota, for example, is that the outcomes have improved for consumers, it's increased efficiency for the courts, and there's a lot of high satisfaction with the lawyers they've interviewed who are actually working with these paraprofessionals. There's still some opposition, but they're seeing positive feedback from the lawyers. They have gotten some feedback as well in Utah, where lawyers that they've interviewed have said that this has actually added to their business model. It has enabled them to capture a previously untapped market for their law firms. So they've been able to capture more business where a partner or an associate may not be able to perform those services for somebody, but their licensed paralegal who is in their firm is able to do that. So this does have an impact not only to access, but it has an impact on the business for the firm and helping the firm sustain business that it might not have otherwise reached. Next slide, please. So I mentioned alternative business structures, and I'm going to look to wrap up quickly here. You see here, Arizona eliminated its Rule 5.4 that prohibited these, and this describes the model. Next slide, please. And Utah took a little bit of a different approach. It is using what's called a sandbox. So a sandbox is actually a policy tool. It's a regulatory policy tool for experimentation with different business models under kind of a loosened set of regulations. It allows innovation in that more loosely regulated environment with adjustments made as needed based on the goals of the program. And Utah's sandbox has created a risk-based entry analysis for those who want to enter the sandbox, and it's based on certain regulatory objectives, increasing access to legal services, protection of the public, et cetera. And when you look at the types of entities that are participating in the sandbox, and there's 42 of them right now, a lot of them are technology companies. That are partnering with lawyers or partnering with others to deliver legal services, either with or without lawyer involvement. Next slide, please. And so, challenges. The challenges we see to some of these changes are coming from within the profession. As I mentioned, change for lawyers is particularly scary. So some of it is there. But there's always this call for data. Show me the data that this is going to help. Well, one of the challenges is getting good data takes time. And so having expectations that you're immediately going to get the data to show that something works, or that maybe it doesn't work as well as you want, and so you need to tweak it, takes time. It's just not realistic to expect it to happen within the first year or the second year, maybe even the third, fourth, or fifth year. And so that's why you see, for example, the Utah Supreme Court extended its sandbox from originally a 2-year pilot to 7 years. So some of the other challenges, how do you assess success? I touched on a little bit of that with Minnesota, but the National Center for State Courts has an assessing improvements to access report that helps jurisdictions evaluate that, as well as the ABA Center for Innovation, which has an initiative where they've launched a tool to help measure the effectiveness of regulatory reform. So I think what I'm going to do is stop there and turn things over to Hallie. Or is it Alexander? It's Alexander.
It's me. Thanks, Ellen. Appreciate that. Appreciate that excellent overview of the access to justice and access to legal services issue that has really plagued the United States for quite some time. And certainly this is a global issue as well. What I want to press upon you, and certainly I think my colleagues here will also agree to this, is that the solutions that we have to put forward need to be multifaceted, need to be multidimensional, and certainly, Ellen gave a fantastic overview of what that looks like on the regulatory side of things. I want to spend a few minutes talking about legal technology and how the technology itself has helped to close a little bit the justice gap here in the United States. So next slide, please. First thing I want to say is that technology in and of itself is not going to be sufficient to get us to the place where we want in terms of being able to provide the requisite assistance that we need here to make a meaningful impact. So lawyers and other legal professionals in concert with the technology itself can do that. Next slide, please. Oftentimes when we hear legal technology, we might sometimes think that there's something about the technology in and of itself that makes it legal tech. But what I want to say is that legal technology can really be any technology that's used for the delivery of legal services or information, okay? And it could be something as simple as using a texting platform, could be using, and certainly something that we have seen over the last couple of years as sort of a silver lining in the pandemic is, wider use of video conferencing to, so that people don't actually have to be in the same proximity to one another to attend hearings or to attend meetings. A lot of this technology has existed for quite some time, and yet we can consider it legal technology because it doesn't need to necessarily be cutting edge. It doesn't need to be the newest and shiniest tech that's out there, so long as we can use it in a meaningful way to help close the justice gap. That's really what we're focused on when we talk about legal technology. Next slide, please. Particularly for A2J, for access to justice, I've identified a few things here that I think are going to be important features for the technology in terms of choosing the technology to deploy to help close the justice gap. Certainly, low cost is going to be probably one of the most paramount factors here. We want to be able to give tools to individuals who don't have access to attorneys, the access to these tools at either free or at very low cost. With that, those tools also need to be easy to use. Okay? We don't want to give somebody a tool that they have to read a treatise on to understand how to use, or in particular, maybe they have to download drivers or additional components to use the tool. We want to just be able to give them a tool that they can use essentially right there, then and there, okay? The other component that I want to focus on as well is that these tools need to be widely accessible. Now, this could mean widely accessible with respect to where it's positioned, right? So we've seen this over the years with respect to, for example, self-help kiosks at courthouses, making those available. As the pandemic has really changed the way in which individuals solve their legal issues and resolve their disputes, where more of the focus is on convenience and the ability to be away from the proximity of the courthouse. we put some of these technologies online. So to the extent that we can make them available at any time of day, to the extent that we can make them available through various platforms, that's really going to be the goal here. A related issue to that is this notion of scale. So the traditional discourse on access to justice has really been that the gap exists because there's this disconnect in the supply of lawyers and the demand for legal services. And one of the ways to address that has been to take legal information so that we're not running afoul of any UPL concerns, and to take that information and scale it so that the information that somebody would have received, for example, in a one-on-one consultation, could then be scaled from one-to-one to one-to-many. So that's a related issue with respect to widely accessible. And certainly something that Hallie is going to focus on later is going to be this notion of user-centered design. The technology has to be given to litigants in a way that allows them, that empowers them to use it, and it enables them to use it in a way that is intuitive to them. Next slide, please. I think by and large, the technology that has been most widely used, the technology that has existed for quite some time and has made probably the most impact in helping to close the justice gap, have been expert systems. Now, expert systems, typically you see these in automated forms and document assembly templates, and many of you here may use that in your own practices. With respect to how expert systems can be used to help self-represented litigants, typically what the goal here is to really help them complete necessary court forms, okay? We still very much exist in a world in which the language of the courts is forms. And so to the extent that we can make that process, that complex process of legal procedure, the heuristics of understanding what it entails to actually go to court, that entire process, we want to make as convenient and as accessible to individuals as possible. So expert systems allow us to do that. One of the other ways to look at expert systems is through artificial intelligence. And this is really one example of rules-based artificial intelligence. And by that, I mean, we take the rules that experts have that accumulated over their many years of experience, over their years of practice, and take those rules and write them into a system so that we have essentially these decision trees. So that if someone tries to complete a form, we can help them go down certain pathways based on their responses. So, one simple example of this would be for somebody who needs to complete a fee waiver. And the first, the condition could be that if they make too much money, or if they don't meet the income eligibility requirements, then they're ineligible to complete this fee waiver form. So expert systems have been widely used for many years. The flip side to this is more data-driven AI, machine learning. But that flavor of artificial intelligence hasn't been as widely used in solving the justice gap issue as expert systems have been. We're starting to see certainly a lot of positive movement with respect to data-driven AI, but expert systems have been in place for many decades now. Next slide, please. These are some of the examples of the tools that we've seen in the marketplace here to help close the justice gap. A2J Author is a program that has been developed by the Center for Computer Assisted Legal Instruction, CALI, and also Chicago-Kent College of Law. And it's a program that I've had the opportunity to work on a couple projects for, and also teach in my own class. And the idea there is that you take this experience of completing a court form, put a graphical interface on top of it. So there's an avatar that walks somebody down this pathway toward the courthouse so that they can actually visualize themselves, participating in this process of resolving their disputes. Hot Docs is a program that is used mainly to develop document templates. And it was a program that was used historically in connection with A2J Author to create both the interviewing interface as well as a document assembly component. Upsolve is based out in New York and really seeks to help with the bankruptcy process. So in a lot of ways, this takes the information, the complex information related to the bankruptcy process, and makes it more accessible to those who don't have access to attorneys. And then we also have After Pattern, which is an open source program, which I believe now is part of NetDocuments, Document, and Neurologic. And these are just, the tip of the iceberg. There are many other programs that are out there, and it's certainly, a good thing to see in the marketplace that we do have a number of these programs available for use. And so, to Ellen's point earlier, that there isn't just one solution for everyone. The great thing about having these programs available is that you can pick the ones that work best for your particular program. Next slide, please. In addition to expert systems, which we can deploy either visually on a computer, we can see expert systems in use, for example, on a number of the different mobile applications that have popped up over the years that have really harnessed the widespread availability of the smartphone, and also just the convenience of having a solution ready in the palm of your hands. But in addition to those, we've seen certainly statewide legal aid websites. And really the benefit here is that we have one centralized website where people can go to in their particular state to find critical legal information. And so here in the state of Illinois, we have Illinois Legal Aid Online. If you go to that particular website, there's a wealth of really helpful information about a number of different legal issues. And on that website, you can also use tools like A2J Author to help complete court forms. Video conferencing, I think everybody is certainly well aware of that. We're on a Zoom right now, and this is a great example of being able to connect with individuals who are not near you. I think, again, this is going to be particularly important with respect to the ability of litigants to participate in the legal process so that they don't necessarily have to take time off of work or spend time looking for transportation or childcare, to be able to also more granularly schedule, for example, status hearings, and so it sort of alleviates some of the log jams and court calls and things like that. Texting has been used perhaps most saliently with respect to disaster relief. So to be able to get really critical information using a relatively straightforward and long-standing technology like texting, to be able to get that critical information in sort of in the environment of infrastructure being down and individuals looking for critical medical aid. That's going to be incredibly important. And certainly online dispute resolution has also been something that we've seen over the years. And that really is sort of a next level technology that enables individuals to take a process that they would otherwise have to participate in the sort of the physical proximity of the courthouse, and take that whole process and move it online, so that you have, for example, asynchronous communications. You have communications at the convenience of both the parties, the court, and the litigant certainly themselves, and also to be able to have access to a wide array of documents readily available on a portal. Online dispute resolution has really made that effort a lot easier. Next slide, please. I want to just spend just a quick minute here with respect to funding, because with this technology, we need to be able to fund a lot of these efforts. I want to highlight in particular the Legal Services Corporation, which is the largest funder of civil legal aid in the United States, and in particular their Technology Initiative Grant Program, which has been in place for a number of years now. It's a program that legal aid organizations can apply for grants for with respect to some of the technology initiatives that they want to put in place that helps support either their lawyers or the administration of their particular organization. And that really serves this mission statement that the Legal Services Corporation put out, I believe in 2012 or 2013, in connection with their Tech Summit, which is this notion that we need to use technology to provide some form of effective assistance to 100% of people who need that legal assistance. And again, in that traditional discourse, it's often been framed in a very lawyer-centered manner, individuals who don't have access to attorneys. But that the justice gap, as we've seen in those statistics that Ellen showed earlier, is certainly it's a bigger problem than simply just the disconnect between having a lawyer and not having a lawyer. Next slide, please. It's great that we have a number of these technologies in place. Very pleased to see that organizations and agencies like the Legal Services Corporation are supporting these initiatives, but it's not enough to have robust technology, even something, as robust as online dispute resolution. Those technologies, those platforms really need to be designed with the user in mind so that the technology, the impact that it makes is meaningful for the litigant and really the user of that particular technology. So with that, I am happy to hand it over to Hallie to speak more about user design.
Thank you so much, and apologies for the quick blip while I share my screen. I am the problem child, and I added edits to my slideshow at the very last minute. So hopefully this will be up and running. Here we go. Excellent. And thank you, Alex, for that great transition. I'm very excited to dig into how we might bring users into the design process. But I just want to zoom out for a minute and talk about what design actually is. I think a lot of folks think about design as how a thing looks, visual design, which actually is most of my work, but it's just a teeny tiny piece of the design puzzle. So this is a quote from Margaret Hagan, the queen of legal design. She says, design is an approach to problem solving. So this is processes, tools, mindsets that we can use to spark innovations, to solve problems. And so there's a whole host of different outputs that design processes and tools can create. So some of the tech tools that Alexandra was talking about might mainly fall in the product design or service design area here. The innovations taking place in the regulatory reform space might be in sort of the service to system design zone, but they're really all interacting with each other. These are not hard and fast categories, and these are tools that can be used across all different kinds of problems to create all different kinds of solutions. And this is something that's already been going on in the legal space, which is really exciting. I loved Alex's point that, tech doesn't have to be new to be meaningful. And I think this is true of problem solving generally. We don't need to reinvent the wheel, and design as a discipline has been around for ages, but maybe what we as a legal profession need to do is sort of expand our concept of what our wheel looks like and look at some other wheels and bring in some stuff there. And this metaphor is getting really out of hand. But the point being that there's a lot out there, and we can take advantage of it. And this is just a very, very small sampling of folks in the US who are doing that. And this is happening worldwide as well. Really, these are just the folks whose logos I could find quickly. And two of these are admittedly my initiatives, the Creative Advocacy Lab here at the University of Utah and the Graphic Advocacy Project, but there are so many more exciting applications of legal design happening all around the world. But I would not want you to take from that that only experts can be doing legal design. And so now I'd love to return to this point about how we can bring users into the process. And really, the most important for me use of design thinking is this way to bring in the folks who are actually experiencing a legal problem to drive the solution and to ensure that what we are creating actually meets their needs. It sounds really obvious, but for me, hearing about this for the first time, it was a mind-blowing moment, this idea that we would actually be able to bring folks who are going to be using these solutions into the process, that they are experts in their lived experiences and in how the problem impacts them. And so there's sort of a lot of different ways to do this. This is just one visualization of a user-informed design process from Service Design Vancouver. But the basic idea is that we can use all these design tools and mindsets in the access to justice space to make sure that folks who are representing themselves in court or struggling to find the right court forms or struggling to stay in their homes are actually getting solutions that meet their needs. And this is an iterative process where, feedback is never over. And so you might create something and then you go back, you get more feedback. Ideally, you're involving users in every part of the process, doing community-led design where users are really driving it instead of lawyers. And that is sort of the most effective way that we can sort of start to get at some of these access to justice problems. So I am just tackling a teeny tiny part of this, which is legal information design. So back to Margaret's wonderful pyramid of design outputs. Information design is that little bitty bit at the top, but it is all around us, right? Every time we look at a sign, every time we go to a website, everything visual, audio, there's so much information around us And so we're actually taking in information design so often that we honestly don't notice it a lot of the time. But so if design and legal design is an approach to legal problem solving, information design is really just an approach to the problem of sharing legal information. Okay, well, why do we need to do that? Well, because access to justice requires access to information for so many reasons, right? Ellen is pointing out that we can't volunteer and donate our way out of the access to justice gap. So, you know, folks are going to be representing themselves likely. And also we live in a democracy, and I think folks should understand the laws that impact them and how these things work. There's also, Ellen also mentioned the justice awareness gap, right? Sometimes people don't even realize that there might be a legal solution to their problem. And so we as lawyers have all this information, all this expertise. How can we use design to share that information with people who are not lawyers? So just a couple examples of my work to make it concrete. I am a cartoonist, so I feel like I need to show some cartoons in my presentation. This is an example of a couple pages from a toolkit about wage theft done with a group in Florida, the Community Justice Project. And this is a COVID project about applying for benefits. So these are just a couple examples of how we can use visuals, plain language, this whole host of information design tools that have been developed outside of the legal practice and bring them into our spaces to try and shrink this access to information gap and the access to justice gap, and maybe even to go beyond that and to build more power in communities to change these systems entirely. So with that, I will turn it back over to Tyler to facilitate our conversation.
Thank you, Hallie. Thank you, Ellen. Thank you, Alexander. Really very informative. And that visualization from Professor Hagen's such a, you know, a nice way of kind of enveloping the goal of this this entire session, this entire webinar, to be able to kind of represent the various ways in which systems, legal systems, are being changed actively, facing change actively, and that kind of brings me to where I think, you know, we can get at with the balance of our conversation, and what I kind of thought were the two kind of common buckets of you know, comments that you guys were getting into. And one is, you know, one piece of it for me is, or that I'd like to ask about is, you know, one is common principles, and the other is assuaging the profession, being able to make this change in a way that is not done, I suppose, kicking and screaming, because I think all of us can agree that we think that change is coming, you know, that it is inevitable. My father liked to say that it was the only constant, change. So the idea that technology, that public perception is not going to impact, and public need is not going to impact where the profession goes, seems foolhardy. And yet the profession, you know, in some jurisdictions in particular, seems to double and triple down on systems as they currently exist. So the first, but I want to step back, you know, to this first kind of point, this, you know, set of common principles. If there's regulatory reform coming from one direction, if there's you know, you're coming at it, you're wanting to come at this from a design perspective, you've got technology that's trying to, or that is disrupting both the delivery of law or delivery of legal services, as well as the practice of them. So how lawyers perform their jobs as much as how citizens receive them. How do we reach a set of kind of common principles of these interventions? You know, how do you say or reach a, or, you know, are there efforts? I hope there are there efforts to reach, you know, kind of a common set of principles of approaching these various issues from different disciplinary kind of perspectives and different aspects, different system, you know, levels of systems within the profession, but in a way that is commonly understood to be pursued, you know, in pursuit of a, you know, common set of goals, if that makes sense. And you know, I would start with Hallie. You know, I feel like design probably already has this kind of, you know, as much as it can, a general sense of common principles, commonality. You know, maybe Ellen, the sandboxes do. Whoever wants to go first.
Yeah, I'll jump in really quickly, because yeah, as the pyramid shows, right, we're all using design. Design is being used in all of these spaces. And I think one thread that I'm heartened to see is more common or a value maybe is this idea of bringing users into the process. So I know there are efforts here in Utah using the regulatory sandbox that are making great use of community-led design initiatives. I'm thinking specifically of my colleagues at Innovation for Justice, which is at the University of Arizona and here at the University of Utah's Business School. So they are really driving their regulatory reform experiments here in Utah in our sandbox by going out and talking to folks and learning about what services they need. So similarly, the tech solutions that Alex was talking about, I know that user-informed design is really becoming, I hope, the standard in the tech world. And this is becoming the standard, I think, in legal design and design generally. So I would say bringing folks into the process in a meaningful way who are actually being impacted by access to justice problems would be the first sort of common principle that I think I'm already seeing, which is great.
And I'll step in just before. I know you want to jump in, Ellen.
No, go ahead.
I see a bit of an analogy there in terms of requirements that governments involve public participation in regulatory reform or legislative change. And you know, in those instances, there are kind of a common set of principles of what the government entity needs to do to meet the threshold. Are we getting there?
You know, I think if you want to look, you know, it's interesting because the ABA, for example, has long had policy that the public should be involved in the disciplinary process. You know, a lot of my work focuses on lawyer discipline as opposed to kind of bigger, broader regulation. And so the ABA has long had policy that the public needs to be involved in that. And we have been extremely successful in that. I would say, you know, virtually probably a very small piece of the lawyer regulatory community does not involve some type of public participation. And you're seeing it in different ways globally. For example, the Legal Services Act of 2007 created an overarching regulator that is majority people who are not lawyers. And when I say lawyers in terms of England and Wales, I'm talking about solicitors and barristers and those who provide what they call reserved legal services, because over there, if it's not a reserved legal services, anybody can provide it. You know, Canada has had regulation, Ontario's had licensed and regulated paralegals for over 10 years. So to me, the real kind of common principle, in addition to involving those we serve in the process, is we want to make legal services competent, effective, cost-effective, and accessible. And obviously provided ethically, because that's the other hat that I wear. So regardless of who is providing them. And so to me, when you look at like what the sandbox, its regulatory objectives, you'll see that public protection at the fore, the ABA regulatory objectives, public protection at the fore. When the various jurisdictions are looking at these different ways of helping people access legal services and have access to justice, those to me are kind of the core principles. So.
Yeah, I don't know that I can add anything more than what Hallie and Ellen have so eloquently stated here with respect to some of the core principles. I think what I have to share is just something perhaps it's related to that, and it's just a slight tweak in how we perceive clients, right? Certainly, they're clients first and foremost. So to that extent, they are owed certain duties. But they're also consumers of legal services and consumers of legal information. And I think just that slight tweak should hopefully propel us toward some of the more user client-focused improvements that we've been talking about in the course, certainly in the course of this conversation, and also more broadly in the discourse, which is, yes, we should focus on our ethical obligations as attorneys. We should first and foremost focus on the duties that we owe to our clients. But to the extent that our goal is to give and empower individuals information to help them resolve their own legal disputes in the absence of having assistance of an attorney, I think a slight tweak in just seeing them as a consumer of legal information and legal services, perhaps eventually, will change the way we look at how we deliver those services and that information, so that we get to things like, the optimal solution of user-centered design, and giving people tools that they actually would use, giving them an experience that they actually want, that they would actually kind of relish going back to. Sometimes what I tell my students is think about an example from, your own life, and, perhaps it's in the consumer space, like you bought something and how did that make you feel? And, why is it that we can't have certainly something, that kind of experience in the legal industry? And which is why I'm glad certainly Ellen is here to speak to some of those issues on the regulatory the regulatory perspective. But are there opportunities for us to shift a little bit and give clients and consumers of legal services information, those types of experiences that they are seeing in other aspects of their lives that delight their experiences there?
And Tyler, if I may, you had asked the question is, how do we have a conversation when there's always going to be pieces of any profession, any community that may be resistant to change. And that's, I'm not meaning that as in a negative way or a criticism. It's just, that's our nature, as humans. But I think the most important thing is we have to have the conversations, and they're going to be hard conversations. And there are minds that are not going to be changed. There are minds that may be changed. There are minds that will be changed. But there is value, one, in having the conversation and not cutting off the conversation just because an idea is new or not initially liked. And regardless of that outcome, to me, having the conversation and being educated, the entire profession, and bringing those consumers into the conversation. Because I think as lawyers, we oftentimes think, well, we know who our clients are and what they want and what they need, and we don't really ask. And we need to. And as I said earlier, I think there is sometimes a view in some of these discussions that, it's one way or the other. It's increasing access by these regulatory innovations or other changes, versus lawyers having a successful practice. And as I said before, I don't think they're antithetical to each other. And so I think we need to continue having the conversation, continue educating, continue having sessions like this. I learn a lot all the time. And just keep having those discussions. And I think the change is going to keep happening. The state Supreme Courts are looking to do something, and they're leading. And so I think what you're seeing is, and we're watching, we're learning. And as time passes, you'll get more information and more data, and maybe something that you thought would work didn't. That's okay. I think that sometimes as lawyers, we often view that as failure. I try and look at it as an opportunity to do it differently. And I think sometimes there's that shift in mindset that may need to take place. And I think having these conversations hopefully will at least help, and just understand that sometimes you're just not going to, convince somebody, and others are not going to convince you, and that's okay. So.
You took the transition out. Said it better than I could have too. As we hit these last few minutes, and if anybody has anybody who's been watching has a comment or a question, please feel free to put that in the chat. But as we hit these last kind of few minutes, I just want to ask from something that comes from the design process, which is this iterative kind of process and continuing to evolve, how do you ensure that that process is engaged when, as a bit of a follow-up, Ellen, there's going to be pushback. We see in certain jurisdictions that there is pushback, and some of it quite strong. And so how do we get into a place where you kick off that iterative process if there's a group of people that are so resistant to change that they won't open up the door at all, right? Because I kind of view it as, you don't have to, these jurisdictions don't need to jump all the way in at any given moment. You don't have to be a Utah or an Arizona. You don't have to completely open up for folks to play. But if you're not pushing, a little bit in terms of evolution of the delivery of legal services or alternative, professionals, or what have you, how do you even get this process started? How do you even start the cycle?
Well, I think the cycle started. I think it has started. It's been continuing. And I think you see even in some of the jurisdictions where there's loud resistance, there are also those who are supportive of not just having the conversation, but looking more seriously at the innovations. There was a recent report out of New York, for example, and I can't remember the name of the entity. I think it was a working group, a task force working group. I'm not sure if it was from the bar or not, but it looked at ABS and it said, not now, not for us now. We don't see the data, we don't see the need, we still find high concerns about this in terms of looking at it, they say, from a consumer perspective. But let's look and see what happens in Utah and Arizona, and maybe someday we might take a look at that. Okay, that's not a flat out opposition. That's, we're waiting for some data. But I think the other thing that was interesting is there was another report out, and I think this was a New York State Bar report. And if my recollection is incorrect, I apologize, but that is my recollection, that talked about having social workers be able to provide limited scope services direct to consumers of legal services. So when I talk about allied professionals, so I think there's, it depends what subject matter you're looking at. But New York led the way with navigators. So you see some, kind of shifting sands, if you will, if I can stick with the sandbox metaphor. But that conversation's happening. So even in a jurisdiction or jurisdictions that might be typically considered more resistant, there are still pieces that are moving and the conversation's happening. So I didn't mean to pick on New York.
I feel like this is getting at like a heart of the like values that move work, right? Because I think, okay, if you generally see the system as it's broken, but we can fix it, then you're going to be focusing primarily on top-down change and engaging people in positions of power, and then you really do need to convince them. But if you see the system as working exactly as designed and benefiting certain people over others, and you're trying to create systemic transformational change, then you're already in an adversarial position to begin with, and what you're concerned with is building power from the ground up. And so that is sort of how I would answer this question. Is I am not generally in a position to try and convince people in our profession. I'm trying to work with folks who are not in our profession to give them the power needed to challenge those folks, so that it's not a matter of getting them on board. It's saying, this is how it's going to happen. And I think that the extent of the crisis shows that this is a goal within reach to motivate. Folks are experiencing these problems at such alarming rates. The legal system is not serving them. For many folks, the legal system has never served them or people like them. And so channeling that discontent into power, into organizing, is going to make those changes inevitable, whether our profession wants them or not.
Alexander, do you want to have one last word here?
I actually just the only thing I'll say is that I am in complete agreement with everything that Hallie and Ellen have said. With respect to as a response to whether or not there's resistance, and certainly there is resistance in certain areas of the profession. And I would say that I think that we can take a look at what people are asking for. We can take a look at what people are wanting when they have a particular legal issue and they want to resolve it in a particular way. They're not thinking about it in a lot of the same ways that they used to before. We can take a look at a lot of the great work that, for example, Rebecca Sandifer has done with respect to how it is that people view their legal issues, and whether or not they see it as a justiciable legal issue, and whether or not they want to pursue a resolution that it aligns with traditional notions of how you resolve your disputes. And people are going to want things that are different. And a lot of, and this is certainly echoing what Hallie just said, that this is inevitable in terms of what people are asking for. And I think it's important for us to look at this, our profession, not only as a profession, certainly first and foremost, but also as a marketplace for these goods and services.
Thank you, Alexander. And I regrettably have to bring the conversation to a conclusion there. But the first of hopefully additional conversations during my bar year, and I'm sure many others with various actors that you guys have mentioned, and some that you have not throughout this conversation. Thank you again to Ellen Rosen, Alexander Ravenel, and Hallie Pope. This has been a lovely conversation with you all to kind of lay a wide bit of groundwork as to the current state of access to justice in the United States, and some very interesting efforts to address that gap. So thank you again.